Welcome to session 7. The first speaker addresses the topic electronic resource licenses and the South African law. It gives me great pleasure to welcome Mr. Louis van Niekerk, who is an attorney specializing in commercial law and a partner in Dorrington Jessop. We thank you for sharing with SANLIC delegates your knowledge.
Thanks a lot. Good morning, everyone. I'm Louis van Niekerk. Unlike a lot of you, I'm not a librarian or a publisher. I'm actually a lawyer. And my job today is really to talk to you about the basics, very basics, and you must forgive me if it's too basic, the basic principles of contract law in South Africa, and then we'll look more specifically at electronic resource licenses and some of the current challenges that institutions are facing and sort of a way to deal with them. So that's basically just a short overview of what we'll be chatting about. Like I say, it's very basic. Please forgive me if it's too basic for you guys. You probably know a lot of this stuff already. But I do find that a lot of clients get caught up in the details. Contracts can be hellishly complicated, especially when you're dealing with multinational agreements. And where people often get it wrong is that they focus on the details and they forget the fundamentals. So we're really going back to the first year 101 basics today. The first thing to note is that our lives are really regulated by contracts. They form one of the basic building blocks of society. Every day, in your everyday interactions, whether you go shopping or you're streaming something from online, or you're traveling, or you're buying property, almost just getting out of bed, you are somehow interacting with something that is underpinned by an agreement of some nature. That's how fundamental contracts are to our lives. The very idea of civilization is based on theories of things called the social contract, where we subject ourselves to government, sometimes perhaps not, shall we say, perhaps a little bit reluctantly, but we do. And contracts have been with us from the very beginning, as this extract that I'll show you now from ancient Sumerian law demonstrates. This is actually not a contract itself, but the earliest historical reference that I could find to contracts, and actually it's quite a funny one. If the man had slept with the widow without having been in any marriage contract, he need not pay any silver. So for a lawyer, obviously I'm not looking at when I look at this, I get excited because it refers to a contract and to a potential breach of a contract, and the fact that there's no fee applicable. The sexual element doesn't actually come into it at all. So in theory, a contract is really just an agreement between two parties who have a more or less horizontal relationship with each other. The original theories behind contracts dating back thousands and thousands of years were that you had two people with more or less similar rights, more or less similar levels of power, negotiating something freely, which is captured quite nicely in this quote by Nelson Mandela, which says, only free men can negotiate. A prisoner cannot enter into a contract, which implies contractual freedom and equality of some level. Unfortunately, as a lot of us know in our everyday lives, as consumers at least, we have very little contractual freedom, and we're often forced to sign on a dotted line without even being given a chance to even read the terms and conditions. When I was preparing this presentation, one of the institutions sent in this clause, which they were concerned about, which they found in one of their agreements. And this clause actually implies unilateral change of terms and conditions by the service provider. It is done on notice, but your agreement is implied. You don't actually get a say in whether or not the terms and conditions are changing unless you completely cancel the agreement or walk away from it. Now, in fairness, this type of clause does have a role to play on websites, for instance, where the host or the owner doesn't actually have a way of reliably knowing who the millions of potential users are. But it does not belong in an agreement between two parties that are known to each other and that are actually on speaking terms and have actually signed something. And if you find something in a negotiated contract with a party that you actually know, and there's something like this in it, then warning bells should be going off. In South African law, contracts are actually very simple. They really boil down to an offer and an acceptance of that offer. And it's as simple as that. We have very few contracts that are by law required to be in writing, or that have any sort of formal requirements attached to them. You really just have an offer and an acceptance. Of course, being lawyers, we've managed to fill entire libraries with arguments about what is actually a valid offer or valid acceptance, but I won't bore you with those details today. Even though agreements or contracts don't have to be in writing, my real job here today is to convince you that you should reduce them to writing and you should actually sign the bloody thing. Some of the good reasons why agreements should be in writing is because it serves as an external record, something external to the two parties. So you don't end up with a your word against mine situation in court at great expense, and which is also very time consuming. You actually need an objective external record which sets out exactly what we agree to, what our different rights and responsibilities are. If things go wrong, how do we actually deal with that? You need a very specific record of these things. Also, how will disputes be resolved? Things like which country are we going to resolve disputes in? Are we going to do it in court? Are we going to do it in arbitration? All these things, you actually want it to be in writing so that the other party can't turn around and say, hey, but I never agreed to this. We do tend to have very selective memories when we're up against the wall, and the contracts help to actually prevent problems like that from occurring. Also, compliance issues nowadays, I'm sure all of your institutions have compliance departments. Record keeping is very important from a legislative point of view even, and you're required by law to keep copies of agreements. Very importantly, and I can't stress this enough, people, please don't proceed with a transaction until you have actually signed the contract. And not only signed it, read it, understood it, consulted your legal advisor, and changed it in 50 different ways, and then signed it. Don't ever just sign the thing. If you proceed with a transaction, and you won't believe how many cases like this we actually get, even in massive corporate agreements, where people have negotiated terms and conditions, but they're actually in their rush to start off with this shiny new product or service, they just proceed. And the thing was never properly signed, or it wasn't signed correctly. If you do that, you actually step into the pitfall of being at the mercy of the service provider. Ultimately, they're the one that is sitting with the product or service that you want. They might actually have a monopoly on it or exclusive control over it, and you actually don't have a choice. You have to play by their rules. If you don't have an objective agreement that you have actually signed that records your rights are going to be whatever the service provider tell you they are, and that will be the end of it. You're going to have to go to court and argue, we have this contract and these were actually the terms and conditions that we agreed to, but we never signed it. It's not that easy to actually do that, and it'll cost you a ton of money and a lot of time. In complex arrangements such as consortia like SANDC, if one or two or three institutions don't sign and hand in their contracts on time, it can actually also mess with the logistics of the entire system, and you are actually disadvantaging other members as well, and also the negotiating team. So that's a very brief and basic introduction to contracts. Now we're going to look at the electronic resource license agreement specifically. Now, first of all, a license agreement, and this is not the technical legal approach, this is for the everyman in the street approach. You can really think of it as a type of lease agreement. Most law professors will probably shout me off the stage for saying this because, like I said, that's not the technical definition. But really, what it is A owns a thing and B wants to use the thing, A recognizes there's some value in letting B use it, and they agree to a fee and for a period that B can use it, and B uses it as if he is the owner of that thing, although ownership never transfers. That's really a lease agreement, and the license agreement effectively is nothing different. It has a few extra bells and whistles attached to it. For instance, the thing that we're talking about isn't necessarily a car or a house or your child or whatever. It's actually intangible. It's an electronic resource. It sits on a server, on a computer, or on the cloud somewhere, and it's accessible by millions of people simultaneously. And the licensee is not necessarily the end user. In other words, there's a chain of use. You have the owner and the publisher and whoever at the top. You've got your institutions in the middle, and then you've got your students and researchers at the bottom. And all of those relationships need to be regulated in this type of agreement. So these agreements really follow a sort of standardized script, you can almost call it, or a recipe. Not necessarily in this order. They'll have fancy names for a lot of these things, but at a basic level, these are really the main elements of electronic resource license agreements. And if you are in an enviable position of having to actually read one, this outline will help you to make some sense of what you are reading. First of all, we've got our definitions clause, which you'll find in any well-drafted agreement, whether it's at the start or at the end or an annexure somewhere. This really sets out important terms that are used in the agreement. And if you ever get stuck reading one of these things, chances are you'll find some help in the definitions clause. Importantly, obviously, you need to agree to a fee. In the Sandlik model, because it's a consortium, fees are actually not recorded in the license, the template license that Sandlik uses. I'll refer to that just now. In the agreement itself, that's actually negotiated at another level. So the license agreement actually just refers to a further fee agreement. You'll have license period and renewals dealt with somewhere. That's quite important, whether it's a single year agreement or a multi-year agreement. If you want to renew it, how much notice must you give the publisher, that sort of thing. Then authorized use and access requirements. Now, a lot of people, I mean, the basic theme of this conference seems to be the open access movement. So this is an area of these agreements that might actually change in the future. The terms and conditions might actually change quite radically insofar as access is concerned. And then the parties' various rights and obligations, protection of ownership, data protection, that sort of thing will be recorded somewhere. And it's not necessarily just 5 or 6 clauses, it might be 50 or 60 clauses. It's split into subcategories, but these are really the main elements. And then lastly, and very importantly, there will be some sort of provision about jurisdiction and dispute resolution, especially if you're dealing with a multinational agreement where the publisher is an offshore entity. It's very important to be able to peg down which countries' laws actually apply to this contract, because we're sitting in different countries. If there's a dispute, are we going to resolve it in South Africa? Are we going to go to some international forum? Do I have to go to New York for the next 4 or 5 months to fight this thing out? This is actually crucial to peg that down in the agreement in advance. Now I was going to take you through the actual Sandlik model license agreement itself, but we are running a bit late today, so I'll just refer to it very quickly. It follows more or less the structure, not exactly in this order. You can find it on Sandlik's website, and it has it covers all the bases, and you can use it as a template for signing the agreements between the publisher and institutions. Like I said earlier, there's also a further agreement between Sandlik and institutions that deals more with the publisher, that deals more with the fee agreement and sort of the whole negotiated deal, which is a whole different ballgame. And so let's then move on to South African challenges. And I think it's not really my place to tell you guys what your challenges are. You probably know them a lot better than me. We've got some slightly outdated statistics here, but clearly South African institutions are underfunded. And on the flip side of the coin, we've got the whole fees must fall movement. So institutions are really between a rock and a hard place. There's very little funding available, and at the same time, you get this demand for no fee increases or free education. It's a really difficult position to be in. And I don't think it's one from my interactions that I have had with some of the publishers, something that they necessarily are very open to or sympathetic to necessarily. And I apologize for the publishers in the room for saying that. That's just has been my experience. So this leads to certain contractual problems. One of them is that affordability in a multi-year agreement is very difficult to predict if you don't actually know what your budget's going to be, and with fee increases and all that sort of stuff thrown in. Can I actually afford this in year 2 or year 3 or year 5? Also, institutions, I think, are sometimes guilty of finalizing their budgets a little bit late in the process, which makes it very difficult for the negotiating teams and also the publishers to actually know who's buying into this deal. If we're negotiating a 5-year deal, who's actually going to be part of it? And that does have an effect on the cost as well. Like I say, contracts and renewals need to be negotiated well in advance, like months in advance. It isn't always possible for institutions to get their budgets, approved on that time scale. So there's a challenge of syncing these things with each other. And then obviously the specter of fee increases. I don't even really need to go into that. So what Sandvik has tried to do in recent times is to introduce this concept of an opt-out clause, which is really perhaps not something that will make all parties happy, but it's something that could work and that could address some of these challenges. And it's a clause that simply gives an institution the right at the beginning of the next subscription period to opt out of an agreement. This is a multi-year agreement that we're talking about. Obviously, you'll need to give the publisher some advance notice. It'll have to be reasonable notice. And if it's also only if you can really objectively not afford the product any longer. It will need to be balanced somehow. All contractual negotiations are based on some sort of quid pro quo. William will talk about that sort of thing a little bit later. It needs to be balanced somehow. So either institutions will need to actually get their budgets finalized on time, or you'll face a situation where you might have to pay fees, but only on a pro rata basis for time that you've actually used the product in the next subscription period, if you don't use it to the end of the year. Like I say, this isn't something that's ideal, probably not for either party, but it is something worth looking at and considering, and it will address at least some of the challenges that institutions are facing at the moment, perhaps as a stopgap before we move ahead into the future and towards your more open access models, which I think is really the core theme of this conference, whether or not the traditional subscription-based model is actually relevant in the 21st century anymore, given the technological advances and the fact that we can have something like open access. But that's for other speakers to address. What I can say is, even if we changed overnight to a completely open system with open access to all resources, you're still going to have license agreements. And that's simply because relationships still need to be regulated, even though they're regulated slightly differently. People still need to know what their rights and obligations are. So you're never going to get rid of these agreements. You might simplify them, but they're still going to be there. I've got there an example of one that's been used since 1989 in the software industry, the GNU General Public License Agreement, to great effect in respect of open source software. Nowadays, if you download a piece of open source software and you click that little box, yes, I just want to download it, and you haven't read the terms and conditions, but you've accepted that, the chances are very good you've actually just entered into a GNU General Public License Agreement. Even though it's completely free and open source, there's still an agreement underlying it. And that's really all from me. I'm here to answer your questions during question time, or you can approach me. I'm here for today, and my details are up there. Thanks a lot.
Okay, ladies and gentlemen, I would like to take questions for the three speakers.
The Consumer Protection Act, does that have any bearing on the negotiations for electronic resources, or are we not seen as consumers?
CPA is aimed at consumers, so mostly individuals. It does apply to juristic persons, corporate entities, but there's a monetary threshold that's linked to turnover and asset value, which would probably exclude most learning institutions.
If there would be an allocation, so the consumers, the libraries won't have choice to what they want to buy and who they want to buy it from, because there's money involved.
Sorry, I don't really understand the question.
If a librarian, if libraries should choose a product where they want to buy it and who they want to buy it from, will the Consumer Protection Act allow them to exercise this choice or not? Because you now say there's a monetary value involved, and also we are not really seen as consumers.
Yes, so basically what I'm saying is I don't think the Act will apply to you, so it won't really factor into that equation at all.
Okay.
There might be exceptions. It's actually not an easy question to answer, and one would have to look at each case. But in general, I don't think the Act would actually come to your rescue.
Then, William, I want to ask or April and William, accreditation, and looking at accreditation all over the world for universities now, South Africa fits in on the ranking and the scales of university rankings, and what the government offers, and 14% VAT. Is there any legal ramification or any legal angle that one can take to government and say you are actually deliberately stopping us of achieving higher accreditation rates, higher rankings in libraries, because you are limiting us to buy what we want to buy and get what we want to get with this 14%? That's charged.
From my side, yes, but just my opinion, not necessarily what it is. Because anything, as much as we want to achieve anything, but if legally they need to be taxed, then it needs to be taxed. And we need to operate within that confinement of the law, of the tax. You can argue again why tax food, because we need to eat, otherwise we all die, but it needs to be taxed.
Yes, but if this is influencing the education, and this was not something that was always there, it came in on later years, is this something that one can go to the government as, say, SANLIC or NASA, and say this is the impact of this 14% tax, and we cannot...
As a human rights lawyer and a constitutional lawyer, absolutely, yes. Get a whole group together and just take the case on. Yeah, you've got a right in the well, what I'm saying is I don't know what the answer is going to be, but in terms of the rights and the rights to access and you know, if it's prejudicing, you know, from an education point of view, very definitely you could make a case. No, very definitely.
Okay, I think there's another question from Prof. Daisy.
My question is addressed to Louis. Louis, with regards to the actual contracts of the licensing part, you spoke about authorized use versus all access requirements. We picked up that with the subscriptions and the decline in the funding from different institutions. When one institution stops a particular subscription, the researchers and academics expect another institution to take over, and they want access to the other institutions' resources. How do we handle this? Because it has been a big thing for the past year that, oh, my institution cancelled this particular subscription and I need to access that. And I'm being referred to you by a particular line. How do we handle that? Because researchers don't understand how these things work, about the IP and so forth.
Yeah, I mean, the agreement would really be with a specific institution and for their researchers and their students and whoever. I don't know if you can. You might actually technically be breaching the agreement if those people just physically went to another institution and accessed the information there. I'm not sure. It really would depend on the terms of that contract. The other institution's contract might say that a user is anyone who's got an access card and can access a computer at the library, in which case it's completely legit and you could do it. It really depends on the terms and conditions. So you'll have to read the contracts of both institutions to figure out that one.
Okay, I hope that my colleagues will stand up because I don't want to name and shame. Those who have done it and say, but go to that institution, they must give you access. And they're sitting around here.
It is another question from
colleagues, I just want to actually let you know that that has interlibrary loan consequences as well. Because we are aware that if you're not going to actually subscribe to a certain database, you can't actually get an article from interlibrary loan from another library, and that's been problematic. We're looking at our sort of licensing agreements and stuff like that in terms of how you can do it. But if you don't subscribe to a database, I don't think we can say go to another library and use it.
Institutional subscribers, that when you sign a license agreement, and it is in all of the license agreements, that it is for your bona fide registered students, staff and academics. That does mean that when you have a category of user that doesn't fall into that user group of bona fide students, staff and researchers of the institution, you should not be allowing access. But nobody's policing us, so when I do get the one or two people from somewhere else coming into my actual building, nobody's watching. But I cannot possibly send that out on interlibrary loan because that is traceable. And I cannot possibly do things like that. But it is technically for the bona fide students and staff and registered researchers of your institution. It's very similar to the fact that we've all got Microsoft licenses, but I can't say to Mangosuthu, don't sign a Microsoft license because you can just hop off my license. So I think some things are just like that, whether we like it or not. And that's where the whole interlibrary loan world has collapsed, because in the old days, when you bought a printed journal or you bought a printed book, you could send it out on interlibrary loans and your copyright laws weren't affected. But in this case, it's a contract law that's affected. Thank you.
I'm from Stellenbosch University. Just want to ask Louis about the opt-out clause. If I decide to make use of the opt-out clause in a certain contract, do I have to convince the vendor why I am cancelling this specific product and not any one of the other 100 or whatever that I'm subscribing to?
That's quite an interesting question. I have to add as well that I don't think any of the institutions have actually used this clause yet. So we don't actually practically know what the responses will be. At this stage, it's a theoretical thing. It might be quite tricky, especially if you are singling out a specific publisher. They might ask, why are you singling us out? There might be underlying reasons why you actually don't want to do business with them anymore. So it could get quite tricky, yeah. I think at the very least there will need to be some, we'll always love the word reasonableness and reasonable. So, but that really just refers to an objective standard of some sort. So you are going to have to, I don't know physically how it would happen, but you have to show some sort of financial records that can actually objectively show you can't afford it.
I also
Thank you.
don't think it's necessarily a problem. I think one would just have to read that clause. I mean, as a lawyer, this is now my lawyer hat on, which, is my other life, is that one would just have to read the terms of that contract, the clause in the contract in relation to the rest of the contract, and the words should be there and the interpretation of it.
I saw a lovely lady in red.
I'll speak loudly. Can everybody hear me? Yes. Most of the licenses have a walk-in clause with your users. So it depends on the license who you can give access. So if when they become a walk-in user, they're legitimately a bona fide user of your library. So then they have access, but there are licenses that say no walk-in users. The same with ILL, especially with journals. Some of them say you may ILL, some say not out of the country, some say no ILL. So it just comes to managing your licensing and knowing what can you send to whom and who can use it.